Hi. In this video I want to talk to you briefly about omissions liability, and this is obviously in relation to the actus reus chapter, which is chapter 2 of the textbook. Now, there's a couple of things that we need to discuss. The first one, it sounds sort of painfully obvious, but it's nevertheless a mistake that a lot of people make, particularly when they're spending some time learning about omissions liability and the specific rules in relation to it. And that is very, very importantly, omissions is not an offence. Obviously, you're not liable, you can't be sent to prison for an omission, but rather an omission, as we learn about it, is a constituent element or a potential constituent element of actual offences. So, for example, although I can't be liable for omission, my omission in certain circumstances can lead to my liability for murder, or can lead to my liability for another offence. So, just as a general point, sounds painfully obvious as I say, but nevertheless it's something that can sometimes confuse. Now, when we're thinking about omissions liability, it's something we spend quite a long time on often in lectures. But the important thing to remember first of all is that, if possible, we don't want to apply omissions liability in practice. Because actually, in the vast majority of cases, it's much more straightforward and much more obvious to blame the defendant for something the defendant has done, so i.e. an action rather than an omission. And in the vast majority of problem questions and the vast majority of real-world events, that's exactly what the criminal law is doing. It's looking for a criminal action as opposed to a criminal omission. However, of course, there will be times where it is possible to, where it's not possible to find a criminal action, and so therefore it is appropriate to look for omissions liability instead. The two most obvious would be, firstly, where there is no action from the defendant. So, for example, if the defendant is accused of murder and the evidence demonstrates that our defendant had a young child who they didn't feed, and eventually the victim, the young child, died as a result, it might be impossible to identify an action which led to that result, the result of death. The actions of the defendant were simply going about their normal everyday life. Those didn't cause the death. What caused the death was the absence of the defendant feeding their child in the way they were supposed to, or at least alerting authorities. And so in that sense, because there's no action we can pin liability to, we must look for omissions liability instead. Omissions as a different form of conduct which can lead to liability for, in this case, murder. The other scenario is where we do have an action, but actually for whatever reason we can't find liability for that action. And a useful demonstration of this is the case of Kennedy number 2, for example. So in Kennedy number 2, this involved the supply of drugs from the defendant. So the defendant supplied drugs to the victim self-injected those drugs here, and then that led to an overdose by the victim, simple skull and crossbones, where the victim then dies as a result. Now, the most obvious situation here, in this case it involved an offence, potentially an offence of unlawful act manslaughter, was to focus on the supply of the drugs. So this is an action, a blameworthy action that the defendant does, which seems to contribute to the death of the victim later on. Now, as a result of that, of course, in Kennedy number 2, they focus on this action, but eventually they find they can't construct liability. They can't find liability for the manslaughter offence. And the reason for that, quite simply, is here. The fact that the victim voluntarily self-injected the drugs. And the voluntary self-injection, a free-informed voluntary self-injection, breaks the chain of causation. And so because there's no causation link between what the defendant did and the death of the victim, we therefore can't find liability for a manslaughter offence. Now in this scenario, and of course in Kennedy number 2, this means there's no offence committed. Now what happened is, in a later case, the case of Evans in 2009, is a similar scenario. This time it was a young woman who supplied drugs to her half-sister, who eventually dies of an overdose. Now, the interesting thing that they did in Evans was to say we can't focus on the supply of drugs because, again, we've got the chain of causation problem. But what we're going to do instead is to focus here, focus on this spell of time in between the voluntary self-injection and the death of the victim. And if we're going to say that if there were signs that our victim was overdosing as a result, this creates a duty on our defendant to act in order to try and repair the damage. So at the very least, to call an ambulance to try and save the victim. And the fact that our defendant failed to do that means we can focus on her omission. So there are two ways, as I say. Firstly, there is no action, and so therefore we can only look for omissions liability. Or in a scenario like this, it might be that there is an action, but there's a problem with finding liability for that action, here because of the chain of causation. And so therefore we're looking for an alternative criminal event. We're looking for alternative conduct from our defendant in order to find liability. And in Evans, that's exactly what they found in terms of the later omission. Now, in terms of omissions, in terms of then how to apply them in a case like Evans, is to require a duty, essentially. So, although an action is much more straightforward, if an action causes a harm, then we have conduct and we have the causation of the harm as required. For omissions liability to be constructed, we generally don't blame defendants for what they fail to do. We generally want to only blame them for what they have done, an active participation in the crime. So whenever we have omissions liability, there are three additional questions we have to ask, whatever the offence is that's being charged. The first one is to say, is the offence capable? Is the offence one that is capable of being committed by omission? Now, most offences are nowadays capable of being committed by omission, but there are still a number of offences which aren't. A good example of that would be unlawful act manslaughter. So in Evans, for example, they then had to charge gross negligence manslaughter because unlawful act manslaughter can't be committed by omission. So always check the offence first of all. Is it capable of being committed by omission? Secondly, we then need to identify a duty. And a duty to act. This is not the same as a duty of care, but rather a smaller category where there is a sufficient duty on the defendant that the law requires them to act in some way. So in Evans, for example, that was because the defendant created the dangerous situation or contributed to it by supplying the drugs. That thereby created a duty that she should try and help and try and prevent the harm coming about. And there are various duties which we discuss within Chapter 2 which can amount to a duty to act. And then thirdly, we need a breach of that duty. So if, for example, if we go back to our example of the parent who allows their child to starve, if that parent was, in that scenario, we might charge the offence of murder. Murder is capable of being committed by omission, so it passes this test. Then we say, is there a duty to act? Well, there is a duty to act between parents and their children, so we have a duty to act. Then we have to look at the breach. Here, has the defendant act or failed to act in an unreasonable manner? So if, for example, the parent were tied up, so they had been robbed or burgled by a group of criminals and tied up in a chair, so therefore they couldn't move, yes, the parent in that scenario has failed to feed their child, but they haven't breached their duty. They have done everything that could reasonably be expected of them. They were tied up. It was impossible for them to feed their child, in which case it would fail here and there would be no liability for murder. However, if they were physically able to perform the actions that the duty requires of them and they failed to do that, then there would be a breach of that duty and therefore we could construct omissions liability in that way. But remember, whenever you're dealing with omissions liability, each of these three aspects needs to be satisfied. Now, the last thing that I want to mention as well is the issue of omissions and causation. And this is something that often students struggle with. So here, to find a valid omission, this just gives us our conduct element. This gives us the equivalent of a physical action from the defendant in other circumstances. But we still need to ask where it's a result crime, something like murder, has the conduct of the defendant caused the result to come about? In relation to actions, that's relatively straightforward. If did me moving my body in the certain way that I did it cause the harm to result? But in relation to omissions, that can be a little bit more tricky. Rather than asking, has our omission caused, rather try and think about what is it that the duty of act required our defendant to do? What should they have done? The question then becomes, has their failure to do that reasonable conduct impacted the result coming about? Now, an easy way to think about this is a couple of examples. The first one is in the case of Evans, where there was liability for gross negligence manslaughter. And the reason for that is because the victim was suffering an overdose over a period of hours during the night, and the defendant, rather than doing what was required, i.e. phoning an ambulance, rather simply put the victim to bed and hope that she'd get over it. She didn't, and she eventually died. Now, when we're looking at the question of causation there, we're saying, if the defendant had called the ambulance, could the ambulance potentially have impacted that outcome and prevented the death happening? And the answer there, because it was over such an extended period of time, was yes, there could have been something usefully done to prevent the death, and therefore the omission caused or causally contributed to that death coming about, which satisfies then the actus reus of gross negligence manslaughter. But let's say it happened slightly differently. Let's say the victim in Evans self-injects the drugs and immediately drops dead, or drops dead after just a few seconds, such that even if our defendant did what was reasonable, even if she had phoned for an ambulance, there's absolutely no way the ambulance could have saved the victim. Now, in that scenario, yes, there's a criminal omission, there is an omission, a conduct element, but that conduct element, that omission, has not caused the result to come about. Because even if our defendant had done what was reasonable, it would not have impacted the result. It would not have prevented the harm coming about. And in that scenario, we have our conduct element, but there's a lack of causation. And therefore, for a charge like gross negligence manslaughter or murder or whatever, any result crime, there could be no liability. Okay, thank you.